Good morning. I'm Gerald Newman, and I am the director of the Human Rights Program here at Harvard Law School. And thank you for joining us for this panel on artificial intelligence, promises and perils for humans' rights. We've convened a panel of distinguished experts to delve into the critical implications of AI for humans and their rights. The discussion will broadly address the anticipated effects of AI's increasing integration into society and explore potential responses to these challenges. If you've signed up for the panel, then you've seen the biographies of panelists. I'll give just very brief introductions of them so that we can get into the substance as quickly as possible. Ifeoma Ajunwa is Asa Griggs Candler Professor of Law at Emory Law School and the founding director of its AI and Future of Work program. She's farthest to my right on the table. Next, Julie Cohen is the Mark Claster Mamolin Professor of Law and Technology at the Georgetown University Law Center and a faculty co-director of its Institute for Technology, Law, and Policy. Lawrence Helfer, immediately to my left, is the Harry R. Chadwick Professor of Law at Duke University and co-director of its Center for International and Comparative Law, and a permanent visiting professor at the I-Court Center at the University of Copenhagen. He's currently a member of the UN Human Rights Committee, the monitoring body for the International Covenant on Civil and Political Rights. And Yuval Shani, further to the left, is the Hirsch Lauderpacht Chair in International Law at the Hebrew University of Jerusalem, and among other things, a visiting professor at King's College London, and an accelerator fellow at the Ethics in AI Institute in Oxford, and he is a co-convener of this panel and of the workshop that will follow it. He was a member of the UN Human Rights Committee from 2013 to 2020. This event is co-sponsored by the Human Rights Program here at the Law School and the University of Oxford's Accelerator Fellowship Program. We'll be having 2 rounds of discussion from the panelists and then open up for questions. And for the online audience, we invite you to submit questions through the Q&A function on Zoom. So without more of this formality, please, Professor Ajunwa.
Thank you so much for that warm welcome, and thank you also for inviting me to this very important panel, examining human rights as pertains to the AI development. So I've been tasked today to speak about some of the potential harms that could come out of the advent of AI technologies and the impact of its spread in the world. As I see it, the sort of harms emanating from AI technologies could be grouped into 2 categories. First, they are the dignitary harms, and then there are the economic harms. Now, you might say, well, isn't there a 3rd category, which is an existential threat that we hear so often from Silicon Valley tech executives? And I would say, sure, but in the, I think, immediate or even intermediate future, I don't think that is a serious threat. I think, in fact, the sort of discussions of existential threats from AI technologies may serve as something of a red herring or a smokescreen to distract us from what I think are the very real dangers, which are the dignitary and economic harms that I will enumerate today. So to start with the dignitary harms, I think, as perhaps I spent some time explaining in my book, The Quantified Worker, there is a danger of AI technologies with their capabilities for ever increased surveillance, and which is to say that they can become deputants or really the most vigilant mechanical managers as part of the surveillance industrial complex that Professor Julie Cohen has so tremendously explained in a lot of her work, that they can then reduce human workers to cogs in the machine. They can start to quantify not just human skill, human aptitude, but even human attributes themselves. So with the influence then of these AI technologies in the workplace, you get workplaces where the human is devalued and seen as just another mechanical bit to be slotted into work, to be used up and chewed up and thrown out when they no longer work enough for profit. So that is part of the dignitary harm, which is reducing the value of the person, devaluing personhood, reducing human autonomy, reducing human discretion, and devaluing human expertise. And then you come to the economic harm. With the economic harm, I think it is important to dwell on what AI technologies enable for business. What they enable essentially is a planetary labor market, a global labor market that is borderless, boundaryless, and also essentially shielded from many of the labor roles that would operate within countries. So this sort of borderless nature of the diffusion of AI work technologies that have created this global labor market means that we have a situation where there could be further exploitation of global South workers, that is to say the majority world workers, for the benefit of the quote unquote first world. And this is particularly a keen issue when you consider that many or most country laws do not apply extraterritorially, thus that companies are able to get away with doing things in other countries that they would not be able to get away with within their own countries. And I'll just share one anecdote to really illustrate this issue of exploitation and economic sort of devaluation of labor that can happen. So we know that ChatGPT is perhaps the most visible evolution of AI that we know of as of now, right? And it has gone through leaps and bounds in the few years that it has been discovered. What we do not know widely is that much of ChatGPT is, I guess, owes its existence really to global South workers who do the content moderation that allow ChatGPT to be ChatGPT, allow it to function. And what has come out are the reports that those global South workers located in Kenya, for example, have been subjected to deplorable working conditions where they have been made to view images of bestiality, child sex abuse material without the adequate psychological help that should accompany that. And they have been also paid a pitiful sum, sometimes $2 an hour to accomplish this task. And what these workers have tried to do is to start a union to give them access to better work conditions, because the conditions that they currently labor on for these mostly American countries are actually conditions that would not be legal under, say, the laws that we have in the US, such as OSHA or the Fair Labor Standards Act. But international unionization is still something that is difficult to accomplish and does not necessarily have the same bargaining power as the labor unions that work within a specific country. And I do think then this points to the importance of human rights frameworks that are agreed to, multilaterally by countries, and that could have some teeth in holding companies accountable for how they operate in these other countries, and also for ensuring that all humans, no matter where they happen to be born or reside, still enjoy the same human rights vis-a-vis these AI technologies, whether used in the world of work or in other spheres of life, as the counterparts in the in the first world country, so to speak. So, I'm introducing this topic, and I think, my fellow colleagues will elucidate further aspects of this issue. But I do think a major area we want to focus on is thinking about what existing frameworks of international law can already be deployed to address these issues, right, that I've already enumerated. So, for example, the labor protections. The International Labor Organization, the ILO, comes to mind. How could the ILO play, for example, a key role in ensuring that all workers, including Global South workers who are part of the AI revolution, who are essentially, in some ways, the draft forces driving the AI revolution, are not exploited, right, and still have their human rights defended. So with that, I think I'll hand off to the next panelist. Thank you.
Thank you, Professor Junwa. And I will now hand the microphone back to Professor Cohen.
Thank you, Professor Newman, and thank you so much for having me. I'm happy to be here. So I am not a specialist in human rights law. I'm a specialist in the political economy of networked information technologies, and my work thinks about the ways that those technologies, as they evolve, are challenging the shape of our existing and familiar legal institutions. And so in that light and through that prism, the concern that I'd like to raise and talk a bit about for you is the way that AI functions are becoming subsumed into our information infrastructure, and the implications of that process for what strikes me as a longstanding assumption within human rights law, that humans, either individually or collectively, have the capacity to direct their own knowledge gathering, their own information processes, their own kind of political will formation that then leads them to be able to enjoy individually and collectively civil and political rights. So to begin, what's infrastructure? So the infrastructure can be thought of as sort of the connective structures that are human created that facilitate human and social activities across spaces and scales. So you might think of roads or electric grids and water systems. And you might also think of network communication systems, beginning with information access providers and kind of chaining on up to the backbone service providers, cable and satellite, and so on. In fact, where networked information technology is concerned, there are other layers within those technologies that themselves have come to perform informational functions. So, and the functions of concern are those that are involved in data-driven predictive profiling of human activity. So if you are online using any of the major platform-provided services, you are enmeshed in systems that in the background are constantly collecting the data necessary to do data-driven predictive profiling about your activities and interests and social networks, funneling that data back to the mothership, right, back to data centers operated by the biggest of the big techs, and also funneling it often out to many smaller data brokers within this ecosystem. And kind of subsuming and recycling that information to comprehensively structure the way that the information environment shows you things, whether things that you look for within a search engine, things that you see in a social media feed, things that you find on a major media website where that website subscribes to services for optimizing its own content for engagement by the people that visit the site, services that respond to the demand for advertising, and that are sort of designed to kind of meter and monitor whether paid promotional content receives clicks and likes, and so already this has been going on for 12 to 15 years with an increasing level of intensity. Subsuming AI agents into that process deepens and intensifies that process in two ways that sort of complement one another. The first is that all of the processes that I just described are increasingly now mediated by AI agents and apps and bots that have been absorbed into the services that one is using. So when you go online and search, you'll get the AI summary at the top. When you are on social media, AI will now be involved in structuring the feed and up-ranking certain things to the top. When you are using a productivity suite provided by a leading information technology provider, such as, for example, Microsoft, AI agents will be involved in mediating that productivity. Enterprise AI used by government services within universities and nonprofits and companies will be structuring outputs, and on and on and on. And that's just the first way that AI is enmeshed in the mediation of information work. The second way is that these generative AI services, large language models, image recognition models, and so on, have been trained on the very same information environment, which is itself structured by these commercial and engagement imperatives. So that means, right, because an AI, for notwithstanding the fact that the word intelligence is in its name, can do only what it has been trained to do and build upon what it has been trained to do in particular ways, right? So it is generative, but it is generative in a direction that is infused by all of the data and content that has been used to train it. User-generated content structured within this data-driven predictive profiling environment, paid promotional content structured in the same way, mainstream media content and fringe media content optimized for viewing and engagement. And that's the second way that AI becomes infrastructural. It is trained on an information environment that has been constructed and optimized in a particular way. When those two kind of streams come together, the fact that our search and information production and viewing is mediated by AI, and the fact that generative AI is itself trained in an environment that has been constructed in a particular way, that layer is in between humans and their public discourse, their information gathering, their knowledge production processes in ways that I think challenge the traditional human rights paradigm. It's tough to frame those as infringements of any particular individual rights, and yet I think it is increasingly essential to frame the process within a conception of rights that is collective and that addresses these background infrastructural conditions. Thank you.
Thank you very much. Just on the comment that human rights is not your specialty, this is essentially a conversation that has to be had among people of a wide variety of specialties. And that's the kind of dialogue that the Human Rights Program is interested in. Very much welcome that kind of engagement. Nonetheless, I'm now going to hand to a current human rights expert the microphone, Professor Helfer. No, he's got his own microphone.
I've got my own. So first, let me add my thanks to Professor Newman, Professor Yuval Shany, and the other organizers for hosting this event. It's important to have this conversation, and maybe I'll first start by trying to situate what I'm about to say within the remarks that the two other panelists have just made. So, as Professor Newman indicated, the project that forms the basis of my remarks is a paper that came out earlier this year in the Michigan Journal of International Law called Automating International Human Rights Adjudication. Now, that might lead you to think that, in contradistinction to the other two panelists, that I'm a proponent of doing that. And the answer is, the truth is that that is not, in fact, entirely accurate. That I think there are ways in which automated decision-making tools, including AI, can be used to improve the review of individual complaints alleging violations of existing international human rights treaties. But there are also many pitfalls. So the background to this, to focus on the international system, is that the international regional courts, commissions, treaty bodies have a kind of final line of defense for individuals who bring claims alleging violations of their internationally protected rights. And I should have said at the outset, I'll say it now, that my remarks today are made in my personal academic capacity and should not be attributed to the Human Rights Committee as an institution. So with that out of the way, the question then becomes, what happens when an individual is unable to obtain redress for rights violations at the domestic level, either because there is no redress available, or the redress is inadequate or prolonged in terms of its delay? You then turn to the international level, and the result of this is that we have a series of international and regional judicial and quasi-judicial bodies that are overwhelmed with complaints, overwhelmed with cases. And they have a variety of different functions that they perform, including providing remedies to individuals, hopefully exerting some kind of deterrent effect, but also generating jurisprudence about the meaning of what these treaty rights actually, what their scope and content is, especially in an evolving climate where the concerns that human rights issues raise are not confined to the time when these treaties were originally drafted. So to summarize a great deal of material in a fairly short period of time, one of the things that the paper does is to identify very precisely the kinds of tools that could be deployed by international human rights adjudicators, judges, experts, secretariat, or registry lawyers at different stages of the process of reviewing these complaints. And at the outset, I think the idea, what we're very skeptical of and opposed to, would be the claim that you can have adjudication of core issues where there is an exercise of judicial or quasi-judicial discretion being either de jure or de facto farmed out, if you will, to some sort of automated decision-making tool, whether ChatGPT or otherwise. And there are real risks involved would be in doing that, and I think the risks outweigh any kind of benefit in terms of efficiency or consistency, speed, assistance in drafting of cases to deal with the backlog that I mentioned. On the other hand, I think the really challenging question is, to what extent can these institutions adopt different sorts of automated decision-making tools to assist adjudicators in resolving cases. And the long story short here is that we think that the judicial discretion has to be preserved. And so there will be some tasks that will be more or less easily automated where there is not a large amount of discretion, although we recognize that the line between those tasks in the adjudication process where there is discretion and not is not a very clear line. It can certainly be blurry. And so what the paper tries to do is to identify where different kinds of specific sorts of automation tools, including much simpler tools than the large language models we've been discussing, which themselves could be quite helpful in dealing with the backlog and the processing of cases. But suitability hinges on two issues, and I'll just mention them very briefly before closing, and we can talk about them more in the next discussion. So one is the preservation of judicial discretion. All other things equal, the closer to the heartland of making decisions, or even in a facilitated way, even where humans can then decide, no, we reject the recommendation that the AI gives, that becomes increasingly risky. And indeed, in the European, among others, the European Council of Europe documents, European Union documents, these sort of tasks are viewed as high risk, and as a result require a higher justification. One of the reasons for being very concerned about preserving judicial discretion, both formally and in practice, is because of the different types of biases that can arise, both biases that are inherent in the data sets on which algorithms are trained, so that's something that Julie was kind of gesturing at, and also, and less well known, I think, are biases that arise from the interactions between humans and machines, whether that's a kind of automation bias where you're giving greater credence to the automated outcome, or discounting bias where you're going with your prior determination, notwithstanding what the automation tool generates. So one of the things that I think that can be done, even as technology is very rapidly evolving, is to pay attention to questions of accountability, questions of institutional oversight at each stage of the process, whether it's considering how to implement AI tools, in what fashion, and then also what kinds of transparency, what kinds of information is being provided. Now, for the simpler tools, it's not very hard to explain. Obviously, for those that are the large language models, we don't know what's inside the black box, although sometimes you can have proxy models that help to determine that. So you have to kind of strike a balance between systemic disclosures of information about how AI is used in a process, and on the one hand, and on the other, how in a case-specific way there would be information provided to litigants about how AI was used. And of course, this then relates to a question that I know Professor Cheney has written about, so here's where I'll close on, do you have a right to opt out of any sort of facilitated use of AI? Or do you have a right, if your this case is determined by virtue of that technology, to a human review of the decision that is generated with AI assistance? Thank you.
Thank you, Professor Helfer. And now to Professor Cheney.
Your mic is off. Anyway, yes, thank you, Jerry, and I want to thank the Human Rights Program here at Harvard for hosting us. It's wonderful to be here. I've been here a postdoc more than 20 years ago, so it's always brings good memories to come back here. I also want to acknowledge my own program, the Accelerator Fellowship Program at the Oxford Ethics in AI, for supporting my work and this workshop and public panel. So I want to jump right in and make the initial observation that as the title of this panel suggests, there are promise and perils. We heard a little bit about both about the perils, but also a little bit about the promise. My comments are really going to focus on the question of who makes the cost-benefit analysis, and what is the role of human rights and human rights norms and institutions in facilitating this comparison between dignitarian considerations, economic considerations, evaluating the political economy, the network effect, the information environment, maybe the human condition that is being affected, maybe positively, probably also negatively, when new technology arrives on the scene. I think there is no, it's not very controversial to maintain that AI systems do generate a significant disruptive effect. I mean, they do change quite significantly the ways in which things actually operate in many facets of life, and human rights traditionally have served in such context as a framework of reference that sometimes operated as as Nozick referred to as side constraints that basically identified certain red lines that we shouldn't cross, but often served as a system of principles that enabled us to make value calculations and trade-offs. And I think that one of the concerns here is that this is a field that is developing very fast without those red lines apparent, without these safeguards or side constraints very clear, and often without a very robust principle discussion. And I want to tie this to a broader concern that all of us in the field of human rights have, and that is a concern about democratic legitimacy, because human rights are always have been situated in some relationship of tension with at least more populist versions of democracy that prioritize majority rule and decision making by democratically accountable office holders. And I think that over the years, and of course it's a work in progress, I mean, I'm not sure that we have reached across the board fully satisfactory formula, but I think a delicate equilibrium has been constructed in many countries and probably also at the international level over the years, which human rights is actually a component of democracy. The idea of concerns about tyranny of the majority as an offsetting consideration that could justify placing some limits on majority preferences, some subtle and sophisticated forms of accountability that apply with regard to judges and other decision makers that address some of the accountability concerns. And also in terms of the legal technique itself, a canon of interpretation that in a way kept the decision makers, including the legal decision makers, within a set of expectations and conventions about how flexible or malleable legal texts can be. And I think the concern is when we move to the digital ecosystem, and specifically with regard to AI technology, with its disruptive effect, that this equilibrium is also being disrupted. And this equilibrium is being disrupted because a lot of the decisions have moved away from both elected and unelected officials of the state to private actors, to technology companies that are in a way creating these infrastructures, what Julie has written about as rights affordances, sometimes self-regulation with quite limited democratic input. So in that regard, we are seeing the norms in question being determined on the fly by private actors. And even when judges or other decision makers try to intervene, their toolbox remains quite limited. And in order to robustly protect human rights in such a context, they would have to adopt sometimes very imaginative and perhaps some would say far-fetched interpretations of existing texts, which were obviously created in a very different historical context with the kind of concerns that AI technology brings about, not in front of the decision makers. Now, we did see some, of course, it would be amiss to ignore the fact that there is a regulatory framework, at least in some countries. There is this idea that regulation has the ability to curb technology and also curb the power of technology companies. We have seen, I would say, within the EU, a very strong interest in pursuing regulatory frameworks in order to bring back into the table certain principles and certain side constraints. But if we look at the regulation that we have so far, I would say that from a human rights perspective, that regulation is not up to expectations, because it tends to be either very abstract, and the leading example we have from recent months is the Council of Europe Framework Convention on AI that speaks in very general terms about the need for transparency, the need for human dignity, etc., but does not contain what I would say is an applicable list of rights that could be relatively clearly and easily, and I would say legitimately applied by a decision maker. Or the other approach, the risk approach that we see in the AI Act, does appear to have some idea about rights in the background, but it's not really articulated clearly in the language. So these are mostly technical requirements that pertain to risks, but the relationship between rights and risk remains quite obscure. And I think what illustrates this quite nicely, or depending on one's perspective, perhaps not so nicely, is this idea of fundamental risk, fundamental rights impact assessment. So those high-risk AI systems, they are determined to be high risk on the basis, inter alia, on the basis of their impact on fundamental rights. And once they have been determined as high risk, they would have to undergo fundamental rights impact assessment. But this is extremely circular because we don't have a good source to understand what are the fundamental rights that are at stake. And we also don't have a democratically legitimate mechanism that would actually implement this. This is mostly left to the market forces themselves to implement. And and you can see that this is not just with regard to the AI Act. This is a broader philosophy about self-regulation that we also see in another recent EU instrument, which is the Corporate Sustainability and Due Diligence Directive, that also involves the same process, which requires risk assessment and due diligence by companies, but effectively introduced by these companies. They are encouraged, by the way, to hire independent third parties to assist them. So there will be another chain of delegation to another set of private actors who will basically develop and apply human rights in this context. So I think the question for us over and beyond, what are the specific human rights impacts of AI systems on what are the human rights impact of AI systems, and what are and how do we capture those impacts in the language of human rights, the disruptive impact, is also a question of how do we want to address them, and is the current approach with regard to human rights, which is pretty much, I would say, hands off, and is based, I would say, on two, and with this I will close, two either completely unsustainable or partly unsustainable assumptions that norms that have been developed historically for governments can be transferable to companies, which I would say in itself is a very dubious proposition, and B, that human rights standards that have been developed in an offline world without AI could be fit for purpose in an online world with AI in it. And I think the combined effect of normative gaps, institutional weaknesses, and democratic legitimacy deficiencies render the project of protecting human rights in this space as rather precarious.
Thank you. That was our first round of discussion from the panel. And I'd like to move into a second round, react to what each other has said. And I might throw in a sort of general question into that, which is that we've heard from the different panelists with different focuses about a variety of possible individual, collective, or systemic harms arising from the implementation of artificial intelligence. And I'd like to ask, with regard to these harms, or suggest, one might ask, to what extent are these harms inherent in the use of artificial intelligence? Or are they results of the misuse of artificial intelligence? Or are they correctable features of current forms of artificial intelligence? And if they are correctable, can regulation help correct them? But I'm not posing that as a question that you must address. I'm just throwing that into the conversation.
Yeah, I think that's an excellent question to begin with. In terms of thinking about, AI and whether the harms that emanate from it are inherent or perhaps as a result of misuse, I think you can't help but also address the issue of affordances, as Professor Cohen has written about, which is, once you have, I guess it's that idiom, right? Once you have a hammer, all you see are nails, right? So if AI technologies are built with certain affordances or certain technological capabilities, then they will be put to those users, right? So I think it's perhaps overly simplistic to say AI technologies are just tools and therefore sort of neutral, and that the harms emanating from them are just merely a matter of misuse. I think we do have to consider that AI technologies, although tools, can also come embedded with certain ideologies, certain design features, and be part of a legal political economy that sort of lends them to certain uses, which can then bring about harm. So I guess it's a complicated question, is what I'm saying, which is you can't just look at the AI technologies in a vacuum. You have to look at them in the context in which they've been created. You have to look at them in terms of their design features and sort of their technological capabilities. You have to also look at them within the framework of the rules that enable their use and deployment and such, what they are able to do, and take all those things into consideration to then see their potential for harm or for benefit. And, I say all this to obviously still concede or even just highlight that yes, AI technologies can be used for good, but we can't just expect that that will happen without making sure that that does happen, if that makes sense. So I guess what I'm trying to say, if we want AI technologies to be used for good, we actually have to make that happen. And that can be through sort of design mandates in terms of how they're being created. It can be through sort of frameworks of their use, mandating how they can be deployed. It can be through other checks and balances. You've all talked about red lines and guardrails. So for example, certain jurisdictions have decided to say, yes, we're agnostic, right, about the effects of AI technologies. And as a result, we will institute audits to check if these AI technologies are actually doing well or actually they are doing something more detrimental. So I do think, we can't just think of AI technologies in a vacuum. We have to think about what are the underlying contexts? How do we then create a context that will allow AI technologies to operate for good of society?
So I like the framing question too. So the to the extent that the harms are the result of correctable, right, it's necessary to go all the way back to the training data to address the correctable features. And and that's very hard to do, right? Because there is, it is taken as sort of unchallenged and unchallengeable fact that it is absolutely essential to train AI on all the data that there is. And that if you do anything less, you're sort of not going to be able to make good on the promise of AI. And we just sort of pass over the fact that a very, very so that's thing one. But thing two is it's not just the data imperative, right, doesn't just exist in a vacuum, right? It's yoked to a much more specific collection of beliefs or that sort of come together in an ideology, right? At the end point of all this training on all the garbage that there is supposed to be artificial general intelligence, which is the point at which AI will finally, depending on your preference, become as good as or better than humans, or just jump the shark and become totally uncontrollable, right? But this is, but it's yoked to other beliefs, right, about sort of hyper rationalism and developing advanced digital technologies of all kinds to make humans better, to achieve long-term betterment for humanity as a species at some far time in the future, to settle outer space, before the planet becomes uninhabitable, right? So there's this acronym TESCREAL that stands for TESCREAL that stands for all of the ideologies. So if you're watching online, Google that and read about it. But the asserted imperative to use all the data that there is to make artificial intelligence the best it can be is embedded in a much more robust and much more intractable set of beliefs. And so thing three, what helps to make these beliefs so intractable is that they are espoused by really powerful and influential people, right? So it is funny, right? Hope here, look, are these they're all now owned by the big tech companies. And there's a sort of inevitable gravitational logic to that because you need the data center now kind of mobilize. The guys, and they are guys who control the big who to boards, they have, except for Microsoft, their companies using a dual tier stock system. So they always have more than 50% of the voting power in the company. So that's not a law of nature, right? That's a corporate governance decision. But they run the company personal fees. It makes them relatively impervious to the regulation that you asked about, and it's well established at this point that when they don't want to obey regulation, they just don't. And it's ideological, right? It ties back to these beliefs about what AI has to be used for. And so if one were to be concerned about this, one would have to find a way to break that vicious cycle.
Thank you.
So I was more caught up in listening to Professor Cohen, but maybe I'll continue with this idea of harms and think about it in a couple of different ways. So first I would say, imagine that you could make the use of these various AI tools so that they were free of errors, right? Just hypothetically, whether it's, however that would be for whatever task. Would that, because it's faster, more accurate, is there something nevertheless that is inherent in the human exercise of authority in certain contexts that should be not delegated de facto or de jure to AI on normative grounds? And I think we don't ask that sort of question in the same way for all of the very eloquent reasons that Professor Cohen mentioned. So maybe in thinking about harms, obviously we think about direct harms. A lot of what we've been talking about is direct harms that come from the application of particular technologies. What I liked about the pairing of Julie and Efuema's comments is there was also a sort of understanding about upstream and downstream, more indirect harm. So Efuema, you talked about the workers in Kenya, right? Some people are putting data into systems, are reviewing content moderation determinations made by AI there's a lot that's actually happening in the offline world that makes the online world function, which has become invisible. And then Julie, your response was, to think about, well, in addition to all the other things you talked about at the heartland of regulation, how do humans stay informed? How do they gather information? How do they make decisions? All of that is further removed from maybe specific concerns about transparency or accountability, but it has really important downstream effects in terms of creating harm that I don't think we fully understand. And this then links a little bit to the point that Yuval was making. So in some prior time, not that long ago, you might imagine that whether it's national or international institutions could begin to develop sets of principles that would either close gaps in the legal framework or promote accountability, and would do that in such a way that they would be able to address some of the democratic legitimacy challenges that he also raised, which I think are always, they're omnipresent, but there are ways of at least mitigating them. So there might be ways to generate norms that were outside of a kind of formal political process, which could then lead to regulation, which could then potentially have some impact on the private actors that, as we've just heard, of making these decisions. But I think that's becoming increasingly difficult to do. And it's not a surprise at all to me that the Council of Europe Framework Convention that Yuval also mentioned is at such a high level of generality. I just don't think there would be political will for being more precise. And indeed, even in the EU context where we're talking about the AI Act, there was huge, political economy issues of lobbying and so forth. And even then the concern was this act may be outdated by the time it's written. So that doesn't really help to answer the question. It just, I think, expands the different types of harm that are involved and the challenges of trying to address them through regulation.
Thank you. Professor Cheny?
Yes, so the AI Act is a good example because there is currently a conversation in Europe about at least delaying the entry into force of parts of the AI because of its alleged negative economic repercussions. So this is indeed like you said, Larry, I mean, it's very difficult to regulate. And even when you have crossed the Rubicon and you have regulated, apparently it's like in a horror film, right? I mean, the bad guys come back in and the whole thing starts again. So I think on the political economy side, I fully agree that this is a thing that, I mean, this is a choice. I mean, this is a choice. It's a hard choice, but it is. This is not something which is intrinsic to the technology. This is intrinsic to our political and economic system, and the fact that in a way we've seen many of the same issues, and we've had many of the same conversations 30 years ago when the internet was in a way made central in our lives, and then 15 years ago when social media platforms became very central. And now we're having a similar conversation about AI systems, perhaps cuts in the other direction. Perhaps it does suggest that there are certain affordances and political infrastructures that make it very difficult to break this cycle. But this is something that I would say is technology neutral. This is something that has to do with our institutions of government, with our political system, with our legal system, etc. Where we get to the technology, I would say that again, I don't want to sound like a doomsayer, because I do think AI systems do have incredible potential in terms of rendering very sophisticated and useful services widely accessible, in the same way that the internet, made, a very positive effect on our lives. And well, social media probably it's a more it's more contested. But I mean, certainly if you have systems that are cheap and accessible and reliable and more accurate than human beings. And I think there is no reason to believe that we will not have such systems in place, or that we already have in many areas of life such systems. This is something that we should, in a way, embrace and congratulate and look for ways to use in order to enhance human rights, including by making mechanisms for human rights more accessible and able to function in ways which are more user-friendly and viable. There are two areas where I think we do have problems which are intrinsic to the technology, and there is no, and we would have to take. Eventually, we would need to adopt political decisions as to how much do we accept them and to what extent we want to minimize them. One is the epistemic issue. These are machines that operate through different systems of reasoning than the systems of reasoning that are applied by human beings. And this is the infamous black box problem. I mean, these are systems that are not fully transparent to human beings, partly because the format is not transparent, but partly because the method of reasoning is different from the method of reasoning that is taken by human beings. I'm not saying better or worse, but it's simply a different way to learn about the world and to to make decisions or recommendations about or predictions about the world. And when you add to this the issue of capacity, and here the capacity gap between humans and AI systems is already very large and is bound to increase in terms of the ability to get the job done much faster and to use an infinitely larger set of data. I think we will, I mean, to the extent that AI systems are going to be central to the way the world runs, we will have less and less understanding of how the world runs and why things are as they are. And this is something which I think is intrinsically different about this technology. And there is a question whether we want human rights to be part of the response to this paradigmatic shift. Here there is, of course, within the technology, this explainable AI. So there are maybe technological responses, although we have to understand that explainable AI is in a way a mirror image of the actual decision-making process. It's not it's an attempt to recreate, to reverse engineer the decision-making process in ways that will be that will be intelligible for humans, but it doesn't necessarily change the nature of the decision-making process. So this is one area where I think maybe a combination of regulation, human rights notions, and technology could result in dealing with this, what some describe as an epistemic crisis, our decreasing ability to understand the world around us. And the second is this, what Ifwema said before about the dignity issue, this idea that for machines, human beings are providers of data. They're providers of data points, and they can only view human beings through the lens of the data that they consume within a decision-making process. And this is an approach to human beings, which is intrinsically dehumanizing, because it does not and cannot capture human beings as dignity holding entities that are fundamentally different from other providers of data. And around this context, there is, like Larry suggested, there is this idea about trying to come up with certain human rights standards that would mitigate these dehumanizing dynamics. For instance, a right to a human decision in certain contexts, or even maybe a right to human interaction in certain domains, such as a hospital setting, or a university setting, or a caregiving facility. So these are the kind of areas and the kind of choices that I would say that human rights lawmakers would have sooner or later to adopt.
Thank you. So far we've heard from the experts on camera, but I want to add that there are a good number of experts off camera in the room in which we're meeting here. And I'd like to turn first to the experts in the room to see if they have any questions they'd like to pose to the panel. Daniel? I think we need to get the microphone down to you. Sorry.
Thank you so much for the interesting and stimulating comments. I wanted to ask, what are your thoughts about fine-tuning? So given that there is this perception that, the training data, we don't have access, or it's all sort of locked up, or everything in terms of understanding the black box is just also very confusing, there's a possibility where, users or regulators could say, this is a data set of questions and answers that we have decided are appropriate for different moral considerations. Would you think that that might, and then you can stress test with various simulations where maybe these regulating boards could say, these are LLMs that are interacting. What would you think about this as a possible solution to mitigate some of the potential harms you're discussing?
Okay, and you turned yours off, right? Good, okay. All right, so that is the current approach, right? It's not a possible approach, right? The current approach that industry takes is, it doesn't matter what the problems were because fine tuning, right? And then you can argue about what they're fine tuning for, and some of the stuff that's come out about that has been kind of sketchy, depending on which company you're talking about. But if it's, and you will solve some problems with fine tuning, undeniably, right? But if, going back to the initial training data sets, again, what you're dealing with is a system that has been constructed by training over large sets of data that are like kind of the unfiltered human id as constructed by behavioral profiling, self-publishing, up-ranking, trending, etc. It's so deeply encoded into the system to prioritize this and not that. I, for one, am highly skeptical that you can fine tune all of the garbage out, right? What we have seen is that the systems have a pretty consistent ability to come up with new problems, right, or new dysfunctions, and then the new dysfunctions get added to the lists of things that have to be addressed in the fine tuning. Which is, you're sort of like playing whack-a-mole with real life, right? So this problem actually happened and now we can use it as a basis for fine-tuning, and that one actually happened. But what you're not ever doing is sort of addressing the baseline assumptions about what was relevant to include in the corpus in the first place and include in the training in the first place. So it's not like I'm opposed to fine-tuning, it's just kind of a Band-Aid.
Very much agree. So yeah, no, I love that by you, I mean, I love that, Julie really went to the heart of the matter, which is these first order questions of what was even relevant to include or what was appropriate to include and who's making the decisions for that. I think that's what we first have to address. And obviously her point about fine tuning for what, who determines whether it's fine tuned enough and what to fine tune for, like what are the goals, what are the objectives. So for myself, I like to use a word, and I have a paper, shameless, I guess, plug for my draft, which is called provenance. So I like the word provenance because I think a lot of what is happening now is we're being presented, right, this flood of information, this flood of quote unquote knowledge as just all relevant, all, appropriately researched, et cetera. And that's just not the fact, right? There are different sort of levels of knowledge, there's different levels of expertise, there's different credibility or credence that should be lent, any sort of information, but we don't get to make those decisions for ourselves. And that's, certainly a point that Julie is saying, which is that we are increasingly having our access to knowledge mediated by these AI technologies, and we're not even like sort of privy to how they're doing it. And we don't then get to make the decision of whether we want to accept how they're doing it, or whether we want to contest how they're doing it. So I really love the idea of provenance. So I see provenance as being actually two ways, right? So there's data provenance, or quote unquote input provenance. So in terms of like all the training data, how was it collected, right? What were some of the issues with the collection of that data? What were some inherent biases or inherited biases of that data? Make that all clear. And then, of course, is the other issue of output provenance. When you see something, whether, coming straight from generative AI like ChatGPT or just online, you want to know how that thing came to be. So that's output provenance. And I think of this as sort of like giving the human, right, all the tools they need to sort of understand what they're seeing and also understand sort of the limitations in what they're seeing and therefore be able to make their own decisions about how they will use that information or if they should essentially disregard that information. But yes, I like the idea of provenance.
Other questions? Please. Microphone coming.
Thank you for this very engaging discussion. My question is for Ifoma. I think that the guiding principles, in a way, were created in a similar context, right? Like transnational companies that were shielded from domestic protections to workers. And I wonder, I mean, how can you, if you can define what is it that it does not work as effectively in the digital environment, the guiding principles, and what's the main challenge that you recognize there? Thank you.
Right. So I think a main challenge is that actually the affordances of AI technologies allow for a disintermediation, or more appropriately, they allow for third parties to absorb the actual corporations of blame. So, for example, in the Kenyan context that I mentioned, these Kenyan workers were not hired directly by OpenAI, the maker of ChatGPT, even though they were working on ChatGPT. They were hired actually by a third-party contractor who also procured workers for other tech companies. So, and that's possible because now everything is done electronically, digitally, online. So that, the fact that you now have these AI technologies that allow this sort of, distance, right, between the corporations and their workers actually sort of threw a wrench in the works, right, in terms of using traditional frameworks, legal frameworks to hold companies accountable. That being said, I take to heart, Larry's point about, yes, some of these existing frameworks did not even contemplate or conceive of the AI technologies that we have today, and therefore may be woefully inadequate, in terms of then governing those technologies. But I do also think that we shouldn't necessarily throw out the baby with the bathwater, so to speak, right? There are still some, I would say human rights frameworks that could still be amenable, right, to helping maintain the human rights that we have sort of recognized. So, for example, with the Kenyan workers context, I could imagine, for example, the ILO coming up with a framework of fair living wages, for all countries. So having and this is something that they have started to work on actually since I last spoke with them, where, they have a table where it shows you like, here are the fair living wages that you should pay for each country, right? As determined, obviously, in consultation with experts in those countries, right? And that's something that the ILO could provide as a guiding principle for corporations to follow.
Using AI, of course. Other questions from the room? Esmar.
Thank you very much. Very interesting conversation. I realized that the conversation that we're having is probably 99.9% about what AI could do to humans when we focus on the negative. But in the sector, there is also a conversation about if AI systems become conscious, should they have rights? And that's currently it's in the fringe. So they talk about model welfare and what that actually means. Do you care to comment on that? It is something that we should welcome as the human rights professionals. Is this a distraction? For example, if it means taking away resources from the core conversation that we want to have, is this something that we should push back on? So over to you.
I will hand over the microphone in a moment, but first to say, yes, I'm very taken with the idea of conveying the right to life, conferring the right to life on potentially immortal non-human processes. Yuval, would you like to respond?
Yeah, I mean, thank you. This is a very interesting question, which is starting to enter into the discourse from a variety of directions. I think 2 years ago, we were very enamored with this idea of the metaverse. And I think there was, which is, and you know, this is why Meta is now Meta. But this is, and I think around the development of the metaverse, there was also a parallel discussion about avatars and whether they would have rights. I mean, my position on this is quite pragmatic in the sense that if this is something that would promote human welfare, because humans do in a way delegate certain powers and responsibilities and tasks to these entities. And in order for these entities to function satisfactorily, they may need to have some legal rights in a similar way in which corporations have been developed as a long arm of human beings that, you know, to which we delegate responsibility and certain tasks and maintain a legal degree of separation. So I can see this happening within that context as well. Should we call that human rights? That I am less persuaded. Of course, human rights, you could criticize human rights for being an anthropocentric project, and people who work in the environment are quite critical of this tendency to conceptualize human rights environmental problems from a human rights perspective. I would imagine that my answer to you would be subject to the same criticism that this is, but maybe at least we could make the case. I mean, unless you come with a strong moral claim that we should extend human rights also to non-human entities, I would be content with this more pragmatic approach of dealing with it. I hope that.
2000% it's a distraction. Okay. It's just like not even a close question, right? If you look, so especially, we're sitting in a room at Harvard Law School. I have nothing against the place. I have a degree from it, right? But we have to acknowledge that there's a category of questions that are like catnip to the highly educated, of which giving human rights to AI agents is one. I teach copyright law also, so I'll put on that list, like, can an AI be an author? Who cares, right? To the extent that it is distracting our attention from this very large and very intractable list of, as Yuval said, normative gaps and institutional deficits. So really, do we want to spend even an iota of our energy right now defining fundamental rights for AIs? It aligns, by the way, with what I described as that TESCREAL research agenda. There are pieces of it that involve sort of figuring out how to send our disembodied personas into space. Again, when the planet becomes uninhabitable because of all the energy that training AIs is rapidly starting to use up. This is not what should be our priority now, if only because maybe it would be good to be a little risk averse, and that plan could go wrong, and then we could just end up on a burning planet with a bunch of disembodied AI agents that we've given rights to, and no sort of even medium-term future for them or for us. So I'm sorry to be so emphatic, but really I'm not. The stuff makes me crazy. I think people in places like this should be rank ordering the priorities a little more aggressively.
Being emphatic makes a much better panel. Yeah, please.
Hi, everyone. Thank you so much for the discussion. So this is a question for, I think, all of you, both human rights lawyer and AI law experts, but it's about where the future of AI fine-tuning is going. I don't know if you've heard of no-code fine-tuning. So this is one area, this is my area of work. So I'm mostly working on fine-tuning for legal applications. So now we're building an open source platform that allows judges and lawyers to build, instill knowledge in natural language. So the idea is that, and I think this is we're trying to solve the problem of error rate and hallucination, especially in law. I mean, I don't know, the latest evidence shows that 60% of the output is there's an error. It's not necessarily hallucination, but so we're solving basically now our recent work. Both we tested that method, which is we call this like reasoning graphs, and basically integrate a bunch of agents to impose some guardrails, but they're not imposed by the data, but by the experts. So that's solving the problem of just basically training on data. And I think our assumption is that because AI is mostly trained on data, so there are two problems with the data when it comes to legal data. The data, the case law, unfortunately, is very much skewed, and it's only the tip of the iceberg. When you think about employment law, 99% of the disputes are resolved through negotiations. So if we're training on case law, that's basically omitting 99% of the relevant data. And the other problem is that I think the method of computer science being used over the last 20 years is essentially dumping data into a system and feedback prompting. We're just using thumbs up, thumbs down. It's a little bit like if, we as law instructor, we just handed over a textbook to students and letting them learn on their own. And the only feedback we gave them is a thumbs up and thumbs out. So this idea is that we basically open sourced the code at some recent hackathon, and now we're facing a new problem. Is that we've got tons of people building all sorts of like different reasoning models. They're much more powerful. They don't make a lot of errors, but it's causing a lot of new problems because we don't know how to set up a peer review system, what this means from regulatory standpoint, liability. And so on the one hand, we could keep controlling and closing the system prompt. Now we opened up the system prompt, which is something that OpenAI will never open up to us. But now we opened it, and then we have a lot of malicious actors playing with the system. So now the question is, yes, it's much more performant. The hallucinations the rate is much better. Sometimes actually hallucinates way worse. So when it's worse, it's way worse. And also the problem, like we don't know how to manage and also it's kind of new, like the concept of an open source platform in the legal community and also probably other professional communities. It's going to happen in medicine. It's going to happen in many other areas. So I'd love you to take both from a legal standpoint and from a governance standpoint, like how do you go about it? Because that's where I think we're not the only, this is an open source platform, but there are many other I think, and I know in the defense industry, it's happening as well. So I think this is probably beneficial to hear your thoughts on how to go about this governance process.
Well, I think that you now have a product which the government should be putting into immediate use.
So I had the benefit of hearing a prior presentation from Sam a few weeks ago. So, so I think I just want to situate this in light of what we were talking about. So what you're doing is going back to first principles and saying, oh, this doesn't work, right? I'm going to build it from scratch. I'm going to build it with expert input. I'm going to build it open source. I'm going to, all these positive things. And I'm super in favor of it. I think it's a great idea. I think it's a huge amount of work. And I don't know I mean, you're saying the challenge, at some point we'll talk more about the challenges you're facing, how you're overcoming them. Not surprising that you have challenges or that they're different. But let's just assume, and this is no knock on the project, which I hope, very much hope succeeds. But if it does, my fear is the problem you will face is at some point it will become co-opted. Now going back to if Wema and Julie were saying that somebody will come along with an offer that you cannot refuse and take it over, or try to take it over. And then you will face, you as a human, a decision point about what to do with it. Now, maybe you can build in safeguards for that. And again, this is all kind of at a meta level away from that. So I hope it works, but if it works, they will come. And then what will you do?
If you build it, they will come. No, but I do want to connect this to. I also I mean, that's a great project and well done, and I really don't want to throw cold water on that regard. But I think there will be things that it will solve. But like you said, there will be areas where it may create new problems. So I think on accuracy, which is a general concern, this would be a very important project. And also, I would say on bias, which is something that with fine-tuning, we could actually make significant progress on biasing. There are still fundamental issues about, okay, what do we do with unsupervised learning and our ability to interpret and predict the products of unsupervised learning and to understand them. And there's also going to be questions about control of data. I mean, who actually has a say on what enters the, Julie mentioned IP. There is this huge battle now in the UK over AI legislation and access and fair use over artistic products. And then the dignitarian issue, of course, if you were to apply this in a courtroom scenario, this would so these fixes are, I would say, at best partial fixes, something which does generate questions of a very high magnitude.
So the problem you described is actually a problem of governing knowledge institutions, right? And so where Yuval gave us the tension between like democratic legitimacy from a populist perspective versus kind of human rights constraints. There's a tension in knowledge governance between, sort of control and openness. But without making any comment on what you've all said earlier, which I loved, by the way, the control and openness are not the only two answers. So there's a really great pool of work that goes under the rubric of governing knowledge commons. Kathy Strandberg at NYU, Brett Frischman at Villanova, and there are these intermediate points, right? So that you can construct a closed pool that is governed by participants, but not thrown open to the entire world, particularly if you're doing things like, genetic engineering, and they've studied it in a variety of contexts. So it isn't necessary, if you want to do open source, to throw it open to the universe and invite in all the malicious actors. The US Census is another example of a kind of closed knowledge governance regime that has invited in researchers under very stringent conditions that they have to agree to. The Food and Drug Administration, I'm just giving US examples, has regime of access to clinical trial information. And so that, like, and a lot of this work is in places that are very different from kind of legal decision systems, and so it might be helpful to just bring that lens to it.
And I think my point is more of a general point than a specific point, because I think you've already gotten very, fantastic, sort of direct responses. I guess I just want to say that I think the word open source, or the term open source, is used kind of like a magic bullet when it comes to AI governance, and it really should not be. I think we need to be a lot more deliberate and thoughtful as to what actually should be open source and what should not, and even how open source should be. So that's just a general comment, that I think, frankly, just kind of encapsulates what you've already heard. But yeah, I think we need to rethink open source.
So I think we are almost at the end of our time, but no, can I ask you either a quick question or a comment for which there might not be time for an answer?
Well, I just wanted to put on the table something that emerged from the problems you diagnosed as a panel, but also a conversation I had yesterday with Joshua Bengio on the basis of his report that he just came out with for the UK government on AI safety. And he basically said, we have between 2 and 10 years to figure out some sort of, dams and safeguards for what's coming. And he seems to think that the solution will have to be some form of global governance. So first with perhaps a small club of countries that are willing to, commit to very constraining regulations or certain rules, or the sharing of burdens and benefits, because it could be that some countries are decimated in their economy by the consequences of introducing AI, and other countries benefit massively. So we need to rethink the entire sort of solidarity and governance of this economic benefits, right? So I'm just wondering whether we could introduce this question of global governance in the mix.
I want to thank the panelists so much for contributing to this introduction for us. And